All right, are you Zakarian Wagner?
No.
And Mr. Wagner, in cause number 24, DCCR 0912, is on probation for tampering or fabricating physical evidence with intent to impair, was placed on probation for a term of 10 years, ordered to go to ISF, and then there was a motion to revoke community supervision filed. We were here previously. Pleas of true were entered in counts 1 through 7.
Actually, Judge,
Is that not correct?
That's not what my notes reflect. I believe.
Let me pull up my actual.
Yes, he pled not true to 1 and 2.
And 6
True-
was abandoned.
6 was abandoned, and true to the remaining counts.
Does the state have evidence with regard to those new offenses?
No, Judge.
Okay. Hold on, let me pull it up. Okay, so the pleas of true, the updated report is not correct. The pleas of true were to counts 3, 4, 5, and 7.
That's what my notes
That's correct, Your Honor.
Counts 1 and 2 related to
Indiana.
Indiana cases, and so the state is unable to have evidence with regard to those. Is that correct?
Yes, Your Honor.
So the counts 3 was a void association with anyone previously convicted of a crime. Count 4 was not to leave the state of Texas without prior approval. Count 5 failed to report by mail as directed, and count 7 was fees and being behind in fees, correct?
Yes, Judge.
I have received the updated report, and also I have received jail incident reports. Has everyone had an opportunity to review all of those?
We have.
The state has, Judge.
Are there any additions or corrections to that updated report, other than the pleas of true that I just corrected?
No, Your Honor.
Not from the state.
Okay, Mr. Rojas, you may proceed.
Thank you, Judge. Regarding the incident in Indiana, because he did plead true to leaving the county and being in Indiana, he tells me he had previously lived in Indiana. When he moved down to Texas, he left some things in his apartment in Indiana, clothing, furniture, things like that. He had a roommate here in Texas who was moving to Indiana, and at that point he had an opportunity to go back in Indiana with a truck and bring his things back. He should have asked for permission, Judge. He didn't get permission. He just thought he could make a quick trip to Indiana, get his things, and come back. And that at that point, when he was arrested with another person, he tells me the charges against him were never filed. The other person that he was with in Indiana is the one that was charged with those crimes. He's asking me to be continued on to probation. And I'll talk about the reporting. He pled true to not reporting to Jefferson County by mail. He tells me he was reporting in person in Orange. He never failed to report in person in Orange. He reported all the times he was supposed to, and I don't see an allegation about that. So I tend to believe that's probably true. He didn't know he had to report to Jefferson County by mail. That's the reason he didn't do. He tells me that's why he didn't do that. Before he was arrested on the motion, he was working construction, doing guardrails on the highway with the Highways Department. Obviously, he lost that job. He says his mother has a friend who has a wood shop. He can get a job doing that if he were allowed to continue probation. He will be living with his mother in Orange, and so he's asking to be continued on probation. He's still a young man, Judge. He's 20 years old. Obviously, he's certainly old enough to know better than to go out and do these things, especially being on probation. But I think he's still young enough to not really understand fully the consequences of what's going to happen to him if he doesn't. I think this has been a wake-up call. He's been in jail since September, I believe. Again, we're asking you to keep him on probation, let this time in jail serve as sanctions, and I don't know what other classes we can give him. He's already been to ISF. But obviously, whatever conditions the court thinks is appropriate, he would follow.
So the person that you were with, that you got in trouble with up in Indiana, has a motion to revoke his probation here in Jefferson County too, correct? Mr. Dyer, Jacathan Dyer.
Do you know about that?
I think that's what he went in for.
What?
I said, I think that's what he went in for as well.
Real quick too, so the allegation of failing to report by mail or online was for May, June, and July. But he had been on probation for several months prior to that. So had he reported online or by mail prior to those dates?
He had been in custody waiting to go to ISF, but he had a pending charge in Harris County. So he had to be transported to Harris County, take care of that, and wait for ISF, then go to ISF.
Okay. And what was that, Harris? I don't remember that.
Unlawful carrying of a weapon.
And what was the outcome of that case?
They dismissed it because of us sending him to ISF.
God, just briefly, Judge, the tampering with evidence, offense as the defendant pled to is a little misleading in that what he tampered with was a firearm, Judge. When law enforcement encountered this defendant, he had one weapon that they initially discovered, if I recall correctly, and then when they put him in the back of a patrol unit, the patrol car video captures him essentially while handcuffed, dumping another weapon. That weapon was outfitted with what was tantamount to a Glock switch. And I say tantamount to a Glock switch because when ATF tested it, it did not meet all of the requirements to be technically a Glock switch. So he dodged a bullet on, well, no pun intended, dodged a bullet on federal charges, Judge, because we were looking at potential federal charges with the Glock switch. So there's two firearms that he was in possession of. Then he's got the unlawful carrying of a weapon in Houston, albeit eventually dismissed. I'd ask the court to take that into consideration. This defendant has an affinity for firearms, and not only firearms, a Glock switch, Judge, you know the damage these Glock switches could do if that was a fully functional Glock switch, Judge. I'd ask that this court revoke this defendant's probation and send him to prison, Judge. And of course, that amount of prison is at the court's discretion. I do understand that he's a youthful offender, but Judge, you know, these youthful offenders with these guns and Glock switches, they're wreaking havoc in our community. And at a certain point, we need to send a message. I'd ask the court to send a message today, Judge. That's all I have.
Thank you, Mr. Coleman. And Ms. Martinez, thank you for being here. Do you have anything to add that's not already in your updated report?
No, ma'am. It is hard to supervise someone who almost immediately leaves the state without reporting it or requesting permission. We wouldn't have known he was up there if they hadn't called us to tell us that they were in custody of their jail.
I mean, Mr. Wagner, the problem here is that I did with you what I do with a lot of youthful offenders, is we give you that opportunity on probation. I send you to ISF up front so that you have the tools to make better decisions so you can be successful in your probation. So I don't have any other tools because I already did that. And your history, so it's not like you just started getting in trouble once you turned 18 or 19. You've been to TJJD. So you were a youthful offender, so much so that they didn't just put you on probation as a juvenile, you ended up going to TJJD. And it takes a lot, in my opinion, it seems like sometimes, for these minors to be sent there. So you must have really frustrated and done something to end up in juvenile prison. Then you get out and you're doing the same thing, and I don't. So you went to ISF. So April 7th, of 25, you get dropped off when you were discharged from the ISF to probation. Placed on a mail-in caseload, courtesy supervision was accepted by Orange on May 21st. 2 months later, you're in Indiana in jail in Indiana. With someone who's also in trouble in Jefferson County that probably wasn't supposed to be or didn't have permission to be in Indiana either, I'm guessing. In addition, we have jail incident reports where you prove to me that you don't want to follow anybody's rules. You obviously don't want to follow probations, and you don't want to follow the correctional officers. You are calling names. I can't even say the words. You're gonna slap the F out of the correctional officer. That's great. You're going to everything is just you telling them, I'm gonna do this my way. I'm gonna shower when I want to shower. I'm gonna wear my clothes how I want to wear my clothes. I'm gonna tell you to hush when you're talking to me. I'm gonna call you names. Here's one even worse. I'm not gonna say these words. Yeah, all right. I'm gonna find that you entered your pleas of true to counts 3, 4, 5, and 7 freely and voluntarily. This frustrates me so much, Mr. Wagner, because you've given me no chance when I gave you every chance. I have no choice at this point, in my opinion, because you refuse to follow anybody's directions. And that means our community is not safe if you're in it. I'm going to find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of tampering or fabricating physical evidence. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was not a plea agreement. You can talk to your attorney about any possible rights to appeal. I need y'all to sign that, and then you'll get your copy. Also, I'm handing you a written admonishment regarding your ineligibility. Go ahead and then I'll read this. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. You are still young. You can make the best of the time that you've got and get out and do better, or you can get out and do worse and be right back in here. So I hope you take advantage of doing better with your life. Go back with the bailiff. Good morning, sir. Are you Alvin Wade?
Yes, ma'am.
And Mr. Wade, in cause number 25, DCCR 1648, you're charged with a third-degree felony offense of possession of a prohibited substance in a correctional facility from July 6th of 2024. Your indictment alleges that you were previously convicted of aggravated sexual assault on a child, a first-degree felony, January 22nd of 1998, and after that was final, you were convicted of failure to register as a sex offender, a third-degree felony, November 26th of 2018. What that means is that if you go to trial and you're found guilty in this case, and if those prior convictions are true, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life. Do you understand the possible range of punishment if you're found guilty at trial?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that has your signature with Mr. Rojas's and shows that the district attorney's office has made an offer, if you would like to enter a plea of guilty, for a 15-year term in prison. So that would be to go on counts 1 and 2 only. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. Do you understand all of that?
With counts 1 and 2.
So counts 1 and 2, that just makes it a second-degree felony instead of the habitual. So it's the offense you're charged with and one of your priors instead of both of your priors. So that's how we get to 15 instead of that minimum of 25. Make sense? And so do you want to reject that offer and have your case set for trial? All right, we'll get your case set for trial, Mr. Wade.
And, excuse me, can I say?
Uh-huh.
I want to invoke my Sixth Amendment constitutional right.
To,
Speedy trial,
you're lucky because in this court, we only have 50 cases waiting on trial. So every case is getting a speedy trial now. So you will get set for trial as quickly as possible and we'll get your case taken care of within a very short amount of time. Now, I wanted to ask you, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release Mr. Rojas. I can appoint another attorney who could begin preparation for trial probably a little quicker. Is that okay with you?
will I have the same right to gather the evidence?
Yeah, of course. Your attorney will get all of the discovery. They'll go over all of that with you, and then we'll get your case set for trial.
And like pictures, like I need him to take some pictures.
Just listen. Let's start with, do you want a different attorney so they can prepare quicker, or do you want to keep Mr. Rojas?
If you're gonna,
Any attorney.
he told me he was a cop out lawyer.
I can't imagine that Mr. Rojas used those words.
I said she'll give you a new lawyer tomorrow. It's just somebody that does, they can get ready faster than you.
You say you're a cop out lawyer that make deals with the DA. I need a lawyer that's gonna help me.
Any of the attorneys who I can appoint in my court are going to represent you to the best of their ability.
Your Honor, if I may, Mr. Rojas has negotiated with me back and forth on this case. We've discussed this case at length, both the strengths and the weaknesses in the state's case, just for the record.
I have no doubt that Mr. Rojas has done an excellent job already. But Mr. Wade, I just need to know if I have your permission to release Mr. Rojas and appoint someone else, or do you want to keep Mr. Rojas? Is that simple?
I'm gonna take your advice.
It's not advice. Don't be putting words in all of our mouths. I'm not giving you advice.
He was a good lawyer, huh?
I'm saying everyone on this list is a good lawyer. So you can keep Mr. Rojas, or you can get someone else off of the rotation who could probably start your preparing for your trial a little quicker. Mr. Rojas just handles a lot of cases for me.
Okay. Then I need a lawyer that, when I handle my case is
Quicker, because you're asking for a speedy trial and all. Perfect. So I'm going to release Mr. Rojas. I will appoint someone today. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. You didn't get your copy?
No, Judge.
All right, let me hold it. There is a updated revocation of update.
Oh, there was an updated one. That's probably why. Okay. Judge, I'm ready to proceed. Okay. Sure. Yeah, I'm ready.
There's one that you can have.
Thanks. Yeah, if we could do a recall, if we could recall it.
Absolutely. I think that's important on this one probably. Just go have a seat, sir. You are Kaisha White. Answer out loud, please. I'm sorry? Yes. This is 24 DCCR 2063. And help me out. What are we?
We pled her back in January of last year.
It was a bond forfeiture.
And it was a bond forfeiture for the punishment hearing. Judge, in speaking with her in the back, she doesn't remember everything that happened last year. I would request a reset to get her evaluated.
Okay.
I don't know, I don't think she agrees with that, but I think that may be the best way to go before we.
Well, I'll obviously you're the one that's speaking with her, and if there's any issue, then we want to make sure that there is everything taken care of before we go forward with any sentencing or withdrawal of plea or anything like that. And so we'll do the order today. Ms. White, there'll be someone to visit with you very shortly, a doctor, to make sure that everything is okay with your understanding of the proceedings that are going on, and then we'll move forward with your case after that. So you can go back with the bailiff. Just go back with the bailiff.
Do I need to file a motion on that, Judge, or?
Good morning, are you Carlos? Right here.
It's Spanish, Your Honor. Would you like me to interpret?
Can you? In cause numbers 24, DCCR 1584 and 1585. And Mr. Salinas, what is your announcement at this time?
Not guilty, Your Honor. The motion that I filed, I've had a chance to review the evidence that the state has, including the Garth interviews. Having reviewed that, I have reason to believe that there is potentially exculpatory evidence located at that residence. That residence is for Mr. Laureano. He is the biological father of the complaining witnesses. The relation to my client is that they were his girlfriend's children, not his biological children. He was the boyfriend. Mr. Laureano is the biological father. He is the reportee of these of the allegations in general. Having used my investigator already and reviewed the interviews of both complaining witnesses, I reasonably believe there might be some evidence in his house, in Laureano's house, that might be exculpatory to my client. So I'm asking, Your Honor, if you would allow for an order for my investigator to enter the house, not to take anything, really to take photos and videos at a reasonable hour with that gentleman.
I think what I'll do on this is I will hold making any ruling on this until Mr. Hoffpower is available to take a look at this, take a look at the evidence that you're talking about, and be here to respond.
He did apprise me of what his motion involved and everything. I just don't know any of the facts on the case enough to really articulate a response, Judge.
I can tell you this is definitely out of the ordinary.
I understand, Your Honor.
Is the allegation, are the allegations in either of the cases that anything,
I don't know how